Well, Elmiron is actually manufactured by a company in Germany known as Benny Farmer Kemp and Company. They actually do the manufacturing of the pill. But I think what will be more familiar to people actually worldwide, but especially here in the United States, is who actually brought it to market, who got it approved, who marketed it, and who sold it. And unlike other drugs, which really have very limited number of entities involved in that process, for some reason, Elmiron has a lot of entities involved. The owners of the license at whatever point in time kept on moving the license around to different corporate entities, selling it, trading it, whatever. So it started off with a couple of companies that have the first name of Baker. Well, we're going to talk about one of them because that one took over from the other one, so we'll start off with Baker Norton. At that point in time, all the way at the beginning, before it was even a drug approved by the FDA, Baker Norton was owned by another company called IVAX. Now both Baker Norton and IVAX are now essentially owned by Teva. Baker Norton held the NDA. That's the new drug application. That's the application that a drug company has to file with the FDA to get approval to market their drug. And they held the NDA until 1997. In 1997, a California company called Alza, ALZA Corporation, which now is owned by Johnson & Johnson, they held the NDA from 98 to 2002. Like I said, Alza got acquired by Johnson & Johnson and one of their subsidiaries. And there's a whole bunch of Johnson & Johnson entities involved with Elmiron over the years. Janssen Research and Development held the NDA from 2002 to 2004. Janssen Pharmaceuticals held it from 2008 to the present. Janssen Ortho was involved. Ortho McNeil Pharmaceutical held the NDA from 2004 to present. All of those are Johnson & Johnson related entities. And then at some point in time, approximately 2005, Johnson & Johnson and their related entities made an arrangement with Bayer to co-promote Elmiron and to sell it, giving Bayer all the proceeds of the sales to the urologists in the United States. So we have a bunch of Bayer entities involved in this as well. Parker Waichman, as most other personal injury law firms, taking cases such as this, and in Elmiron in particular, do so under what we call a contingency fee agreement, where the law firm, Parker and Waichman, will advance all the expenses of the litigation. You will not have to lay out any money for the litigation. We will lay out all the funds required to bring your case to trial. This could be very expensive. Doing discovery costs millions and millions of dollars. We're going to get, I would imagine, tens of millions of pages of documents and data from the defendants. Some defendants like to give us even more information than we're entitled to or that we need, because they flood us with documents. So you go try to find the needle in a haystack. But what we do is we hire experts who have electronic tools, who can mine the information that we get and ferret out those bad documents. Bad meaning bad for the defendants. Because at the end of the day, the one thing that I've learned from doing this for almost 40 years is bad documents drive damages. And when you could show the defendants committed bad acts, really bad acts, bad conduct, hid things they should have disclosed, that drives the amount your clients are going to get. That drives the amount our clients are going to get. And that's why it's so important that we do the work so we have firsthand knowledge of these bad documents so that it benefits our clients. It could cost us tens of millions of dollars, like I said, to bring these lawsuits on. But the advantage is that some clients will have, and I think almost every client, the advantage, like I said, it's going to cost a lot of money to bring this litigation to its conclusion, to a successful conclusion, successful for our clients. And in order to do that, we're going to be spending a lot of money. We have our document examiners. Those experts cost millions of dollars, and they get paid up front. We're going to have the best experts in the world, and they're very expensive. But that's what they cost. It's going to cost a lot for all the attorneys and paralegals that are dedicated to this case, and this case only. But the good thing is, and the thing that benefits our clients, is that Parker Waichman represents a lot of clients that are claiming that Elmiron has destroyed their retina. And a lot of the expenses that we've spoken about already will benefit all the clients. So if there is a resolution to this case, we could amortize or spread those expenses out over all of our clients so that the amount charged to a particular client is relatively small. If we only had 1 or 2 cases, or 5 or 10 or 20 cases, the burden to every client would be extreme. But because we represent a lot of clients in this litigation, they're going to benefit by having us allocate or amortize the expenses in an equitable way. Everybody's not going to get charged the same amount. It's going to be equitably done with court supervision or court-appointed special masters or with settlement administrators, and it'll be equitably done for all of our clients. So it'll be equitably done, spread throughout all of our clients. Now, some of the expenses are client related. For example, if we get medical records in your case from your doctors, those are your expenses. Those do not get spread to other clients. If we get a report from your doctor and we have to pay your doctor for that report, that is your expense. If we meet with your doctor and we have to pay your doctor for that meeting, that is not spread, that is your expense. But at the end of the day, based upon my almost 40 years of experience doing this, the way we handle it is most effective for all of our clients. And like I said, since we have a lot of clients, the more clients we have, the less it is for everybody. So I think the way we've worked it is most advantageous. At Parker and Waichman, we generally do not believe the doctor has any direct responsibility in this case, or in any cases like this. When we go visit with the doctors of our clients, we almost always find the doctor was held in the dark. They were kept in the dark, just like you were, just like the FDA was. And they had no way to know that Elmiron had any toxic effect on the eye or the retina. They just had no way. Now, there might be an oddball out there. Did your doctor do the clinical trial? Was your doctor involved with the defendants along the line and learned something that nobody else knew? Well, that's a very odd situation. They're probably out there, but they're odd. So generally, we don't believe the doctors are liable. We believe the doctors were duped, just like you were. And therefore, this is not a medical malpractice case. And in our retainers, we will tell you that we're not going to be suing any doctors. And if you believe a doctor is responsible, well, then you're going to need to get yourself a different lawyer, because we're not doing it. We believe the doctors were duped just like you were. Now, if we do come across information in your case where we find the doctor was involved in the clinical trial, that he hid the evidence from the FDA, that he hid the evidence from others that were involved, other investigators in the trial, well, then we might have a discussion. But absent our finding of things along those lines, we have no intention to sue any of the doctors. I would say you should talk to your doctor about your injury. You should talk to your ophthalmologist about your problem with your vision. If you're having difficulty with vision, you need to see your ophthalmologist and now discuss with him you're taking Elmiron and inquire as to whether the damage or to your eye was caused by Elmiron, and that maybe you need a referral to a retina specialist so you could have that non-invasive imaging test that we discussed earlier performed to diagnose whether your problems are caused by Elmiron. However, you should not talk to your doctor about the case, because you will now be releasing information that you very likely got from us. And that is protected by the attorney-client privilege. So we wouldn't want you to waive that privilege as to all your conversations with your doctor. So you do not talk to your doctor about the case, but you most certainly talk to the doctor about your problems with vision and what can be done to diagnose whether Elmiron is responsible and what can be done to treat the damage to your retina.